Stogies and boomsticks. Can you explain how your Kyle's Law provision for personal responsibility would apply to ADAs that do not want to charge a case but are made to by the DA? Yeah, so Kyle's Law. I explained earlier in today's show about how we really don't have a functional barrier to a prosecutor being able to drag you into court. I think a probable cause hearing should require that the prosecutor show probable cause to drag you into a trial, meaning that they can show that it's more likely than not that you would be convicted. And a grand jury should have the same standard. But in fact, we have nothing like that. Basically, a prosecutor needs like 5% of the evidence, not 50% of the evidence, to drag you into criminal trial. And I think that's a travesty. And we end up with these trials where defendants for whom there's little, if any, evidence inconsistent with self-defense are dragged into trials with all that cost and risk, generally acquitted, but they're always at risk of being convicted. And the state never comes close to disproving self-defense beyond a reasonable doubt. So after Rittenhouse, I had proposed something I called Kyle's Law that would provide a jury with a special verdict form. And the verdict form would say, if you've acquitted this defendant on the grounds of self-defense, and you also believe that the state has failed to disprove self-defense by even a preponderance of the evidence, when what's actually required for a conviction is to disprove self-defense beyond any reasonable doubt. But clearly, if there are juries acquitting, that beyond a reasonable doubt was not reached in disproving self-defense. But if the state didn't even get to 51%, much less 95%, that the jury can report that. Yes, we believe that the prosecution did not achieve even disproving 51% of self-defense. Then I believe that that defendant should have a cause of action to recover their legal expenses from the state, both from the state treasury generally, and half of it from the prosecutor personally, so that these prosecutors have personal skin in the game, that they're not dragging people into these horrible cases where they don't even believe they have 51% of the evidence, knowing they have to disprove self-defense by 90 or 95% of the evidence. So that's what I would require. And of course, it's generally not the elected district attorney in a jurisdiction that's trying a case in trial. Usually it's an assistant district attorney that's doing the actual trial work. So the question is, well, what about those ADAs who they know it's a bullshit case and they don't want to bring it, but their boss is making them do it? Do you still hold them accountable? And my answer would be yes. You can quit. You're not a slave. You can push back hard on your boss. Your boss could find someone else in the office to take that personal risk under Kyle's Law. Or you can quit. I mean, what's an ADA supposed to do if a prosecutor was telling him to charge people because of their race, for example? Just bring those cases? Or do you quit? So yes, I would still apply Kyle's Law to ADAs who are being forced to bring the case because they always have an out. They don't have to stay in that job. They're not slaves. Joe asks, how goes the diet and how many pounds are you down? So I was down 30 pounds, but the last couple of months have been crazy. I've been off my exercise regimen. I weighed myself a couple of weeks ago at the doctor's office. I think I'd gained 5 or 8 pounds back, but I'll get back on it. It'll be fine. All right. That was all the member questions. I think I've caught up on the super chat questions. Let me see. And I did have a funny video I wanted to play for all of you, but I can't seem to get it to pull up properly. Let me try it again.